If your divorce has turned into a war, you need legal weapons. And most fathers in Illinois have never heard of the tools already written into the law and waiting for them. Every tool in this video comes directly from the Illinois Marriage and Dissolution of Marriage Act 750 ILCS 5. This is part 2, the legal arsenal of our nuclear options series. See the description for parts 1 and 3. Weapon 1, the preemptive strike. Emergency motions under Section 501. The side that seizes the initiative controls the outcome. Section 501 is your first strike capability. The moment a divorce case is filed, either party can petition for emergency temporary orders. Section 501 puts the following in your hands: an order restraining either party from transferring or hiding marital property, temporary possession of the marital home, a temporary parenting schedule before a full hearing, and temporary contribution to attorney fees. Why file immediately? The first 60 to 90 days after filing are the most dangerous period. This is when assets vanish from joint accounts, access to your children gets cut off, and the narrative gets locked in. If you wait for the regular court timeline, you spend the rest of the case playing catch-up. Your attorney files the motion. The key phrase is irreparable harm, meaning damage that can't be undone later. And here's a tactical advantage most fathers miss. If you've kept your communication calm and factual, those messages become proof of your cooperation. Her hostile messages become proof of her dysfunction. That documented contrast is the evidence that powers this legal strike. Weapon 2, financial intelligence. Dissipation. Under Section 503D. Under Section 503D, when one spouse wastes or misuses marital money for personal reasons during the breakdown of the marriage, that's called dissipation. Think of it as spending the family's money on things that have nothing to do with the family. The court must account for it. Gambling losses, spending on a new partner, cash transfers to family members. Every dollar gets charged against the offending spouse's share of the estate. But dissipation is often more than careless spending. Researcher Evan Stark calls it financial coercive control. In plain terms, one partner deliberately drains the money to trap the other and limit their ability to fight back. If she controls the money, she controls your ability to hire an attorney and survive the litigation. Here's how you fight back. First, you deploy the Section 501 emergency motion to freeze the accounts and stop the bleeding. Then you bring in a forensic accountant to trace every dollar that already left. Expect to invest $3,000 to $10,000, but if the marital estate includes 6 figures in hidden assets, that's the highest return move in the entire case. Weapon 3, the interrogation. Discovery as offense. Discovery is not a formality. In combat mode, it's an intelligence-gathering operation and a pressure campaign combined. Begin with interrogatories, which are written questions the other side must answer under oath. Lie, and that's perjury, a criminal offense. Then come requests for production, which force them to hand over documents like bank records, texts, emails, and social media posts. Followed by requests to admit, which force them to officially agree or disagree with specific facts, locking them into positions they can't change at trial. And finally, depositions, where they sit in a room and answer your attorney's questions face-to-face while a court reporter writes down every word. The tactical sequence matters. Written questions first to lock them into answers under oath. Document subpoenas second to verify those answers. Depositions third to confront the gaps on the record. Each phase tightens the net. Here's the psychological dimension. High conflict personalities maintain power by controlling the narrative. Discovery strips that control away. When they're forced to answer under oath and produce documents they'd rather hide, the manufactured story collapses. If they refuse to comply, the court can punish them. That includes blocking their evidence from being used at trial, assuming the missing information would have been bad for them, or ruling against them on specific issues by default. Refusing to cooperate has real consequences. In part 3, we go on the counterattack. Link is in the description. Subscribe and hit the bell. This content is for educational purposes only and does not constitute legal advice. The Illinois Marriage and Dissolution of Marriage Act is complex, and every case is fact-specific. Nothing in this video creates an attorney-client relationship. For advice tailored to your situation, consult a licensed Illinois family law attorney. The creator of this channel is not a lawyer. This is principled fatherhood. We don't vent, we strategize. Stay principled. A.